Anyway, we didn't really close our discussion last week about family law, and you know, it's a contentious topic and one that unfortunately brings a lot of emotion into it. So would you like to pick up from where you left off?
Yes, we were speaking about children and children's rights to the extent that they have them in Barbados in the law courts, and the steps that can be taken in order to secure maintenance and who in particular can go forward. The most outstanding, and that's using the word in its negative context, the worst outstanding feature of our family law is the way that it is actually imbalanced. And it is weighted out of the favor of men to the extent that they have to go to the High Court to secure their rights, as opposed to women who have recourse to the magistrates' courts. It was at that point that we ended last week. And just to continue on that, there are two completely different pieces of legislation, and the manner in which the Maintenance Act is written, it speaks to women. Matter of fact, it is more directed at single women. So to a certain extent, it does also militate against married women who are not receiving support for their children.
Can you just explain that a little bit more for us? So if you're a married woman, you can't go to the magistrate court and ask for support. Let's say you were separated.
Some have. Some magistrates will still hear the matter. Other magistrates will transfer it to the High Court. The action properly is brought within the Family Law Act if the parties are married. I beg your pardon. And it is what we would call ancillary relief. In short, it is not the major part of the legislation. You're not coming for divorce. You may be coming for divorce, but you don't have to be coming for divorce. And you can seek maintenance, and you just simply state in your affidavit that you're not seeking a divorce. You just want other relief under the Act.
Apart from that, are there any other major differences? Is the compensation different, or is it still left up to the court?
The compensation is not different to the extent that the same machinery is used to determine what the amount of maintenance will be. It is in a less formal setting in the magistrate's court, and it will be by conversation with a probation officer, whereas in the High Court you file a document called a Statement of Financial Circumstances, in which you outline how much you earn, how much you spend, what you own, and what you owe. But it is the very same information that you will be giving to the probation officer, and you are expected to prove all of it to the probation officer by receipts, statements, and to that extent it is the same. There is no minimum and there is no maximum. So it really is at the discretion of whoever the judicial officer is.
Brother, the examples of the peculiar cases that could come under the Family Law Act are varied, but what is well documented is how, as you have said, it is skewed in favor of women. Go ahead.
I just want to clarify on that. That is not the Family Law Act. The difference comes with the Minors Act. Right. The Minors Act is what the men have to use to bring an application either for custody, care or control, maintenance from a female, which is, believe it or not, very unusual. Most men will just take their children and don't bother. But having said that, because the Minors Act speaks only to the High Court, men have, if they're initiating the action, to go to the High Court. If an action is brought against a man in the magistrate's court, he can make whatever application he wants as a counter. But he would have to wait for the lady to make that initial step if the matter is to be dealt with in the magistrate's court. But if he wants to be the one going forward, then it is the High Court that he has to go to.
Okay, now that we've cleared that.
We have a caller, so we're going to say good morning to Rodney.
Hello, morning.
Hi, Rodney.
Good morning.
Yeah, I just wondering, if there's two parties, if a party is seeking a divorce in the magistrate court and in the High Court, and one of the parties in their affidavits find out that the person has willfully lied or was lying in their affidavits to the court, what is normally the judge's decision on that affidavit?
Well, what I can start with is that I'm glad you corrected yourself. It is not possible to seek a divorce through the magistrate's court. And secondly, An affidavit is a sworn document as if you were giving testimony in court. The penalty for lying under oath is a charge against you for perjury. I'm not aware it's ever been done in a family law setting, but that is the ultimate action that can be taken against a party who has lied under oath. Obviously, though, if the court discovers that you have lied about one thing, it is going to be a natural assumption that you can lie and probably are lying about everything else. And it will most definitely count against you, no matter what part of the proceedings you're in.
All right, and the calls are coming in. We're liking that. We have Carmen. Good morning.
Good morning.
Morning, Carmen.
Good morning.
I live in Downs Gap, RPC, St. Thomas. I rent a lady a house here, and she's sick with lately, Alzheimer's or something. Her family moved in at 5 and never acquainted me and asked me a question if they could stay in the house. And they are in there abusing me every day. I'm 77 years old, and all they do is cursing me every day and threatening me. I got to call the police and everything. What can I do about that?
You need to stop calling the police and call your lawyer. You are the landlord, and you have every right to have back your property if that is what you desire. The process is by first serving a notice to quit. Once that has expired, then you serve the notice of intention to prosecute, and that notice, once that has expired, you bring an action, a complaint before the magistrate, and the magistrate will give them the definite date for leaving.
All right, so that was outside of what we discussed. In fact, we discussed that a couple of weeks ago.
But obviously a burning issue for her.
We hope that gets sorted. Let's look, I mean, you know, it's more real than imagine that the laws are stacked against the man in the magistrate's court, you said. And you said the option for them is to go to the High Court. How are they stacked there? Is it more equitable?
The stacking really is in relation to expense as opposed to outcome.
Okay.
There is the general belief that men have a rougher time in the High Court, well, in the courts generally. It is my personal belief that men have a rougher time because they are not as forward planning as women are. It is not uncommon in a divorce situation to have an affidavit that's inches thick on behalf of the female and one that's about 3 pages on behalf of the male. And this is because the lady has hoarded every single invoice and receipt and can prove what she is saying in a tangible manner, whereas the gentleman has, I don't want to say been more trusting, but he has definitely not been as careful in maintaining evidence in a real sense.
That certainly disputes the myth of the women being the fairer sex. But does this not have a trickle-down effect where the welfare of the child involved is concerned?
Well, where the welfare of the child is concerned, the investigation, the court does not rely on the information of the two parties in and of itself. There are always investigations done, whether it is magistrate's court or high court. There are always third-party investigations done by the child care board, the probation department, the welfare. All of them are called upon, sometimes all in one setting, but that is unusual. They usually call on one depending on what the circumstances are. And they will deliver a physical report to the court and also present themselves for cross-examination if that is necessary.
Okay, Berla, let's pause. Let's pause and take Lisa, who has to get in her question quickly and go. Good morning, Lisa.
Hi, good morning.
Hi, go ahead.
Good morning.
I call it to find out. I'm going to deal with a situation this morning. A landlord had given me a notice, right? So they're saying 2 weeks to leave the premises. I hope my things and everything are ready. How do I go about it?
The landlord has already put out your things?
Without notice.
Without notice?
Yes.
Well, the landlord has broken the law. The first point at which the law was broken was giving you 2 weeks notice. The shortest notice period allowed in law for a residential tenancy is 1 calendar month. That is the first issue. The second
That's
issue...
regardless of how you pay the rent?
Regardless, that is the shortest period. The second thing is the putting out of your possessions means that your enjoyment of the property has been disturbed, and the landlord does have a right to get back his property, but he has to do it within the bounds of the law, and that is not correct. Whether or not, though, it actually makes sense to pursue the landlord in relation to his having put out your things is another matter, because it's actually a costly process, and it is ordinarily a high court action as well. I am sorry for your predicament, but perhaps the best thing to do would be to seek separate legal advice, because I don't know whether or not anything that you owned was damaged in putting out,
Right.
and perhaps you need to speak with clarity and with further information to an attorney about that circumstance.
And I mean, sometimes we come down on the side of the landlord, because last time we were discussing this, we talked about people damaging their properties and what is their recourse.
Yes.
In a situation like this, where a landlord has certainly decided, you know what, I want my stuff, I want my place, I'm throwing the stuff out. What sort of recourse? I mean, you said it's costly, but what sort of recourse? Does it match the cost you're gonna? Is it worth it?
Perhaps not. That it depends on what it is that you have lost. Within the Property Act, there are certain what we call covenants, which are things that you agree to whether you like it or not. These are in the legislation, things that the landlord must do, things that the tenant must do. And one of the things that a landlord must do is allow you what is called quiet enjoyment. Do not disturb you whilst you are a tenant. That includes the period of the notice to quit. That includes the period after the notice to quit, and between the notice to quit and the complaint, and all the way up to the period when the court gives you to get out.
Right.
So what about police action? Is that, because I'm just thinking,
See,
a landlord
the police
could
are
just go ahead
for criminal acts, and this is actually a civil disturbance, and that is why you would need to go to the courts. You can complain to the police, and the police can go and warn the landlord, and that is about as far as it will get. To get tangible relief, you would need to bring an action, and that is why it depends on the extent of the damage whether or not it actually makes sense to go forward with that action.
Okay. What else would you like to share with us? I mean, today our focus mainly was family and helping people understand better how to deal with situations involving family law. And you mentioned that obviously the situation is, it seems right now that the courts tend to lean more so to the females, who obviously, whether it's for calculating purposes or not, are more organized. What advice would you like to give to men and females who are parents of children?
In relation to children, it really doesn't matter male or female, except to the extent that if you are not married, there is a presumption that the mother is the better person to look after the child, and you would have to prove her to be an unfit mother, which is very difficult to do. In a case like that, though, what a father can do is to take action in relation to the amount of access that he has to his child. A lot of fathers accept the general ruling of every other weekend, but if you really think about it, any given month, that gives you 4 days, and perhaps just one night. So if it is that there is more that you require, then you have to actually take action. That is going to be the general order, but you can have more if you request more. And ordinarily, the courts look kindly on fathers who want to take an active part in their children's lives. It doesn't affect the maintenance, so it doesn't weight it in terms of how much you give to maintain the child, because obviously the person who has the day-to-day care and control has the major expense.
And do you recommend that they do that, especially if, you know, they're not getting to see their children often enough, because you never know when the next court meeting maybe, or what parent is planning what? Do you recommend that they make sure that they have adequate time?
What I will say to the parent who does not have day-to-day care and control is that, similar to how the person who has the care and control and receives maintenance will bring you back to court if you don't pay the maintenance, if it is that you are not being allowed access to your children, you have a similar right to bring that other party back to court, to explain to the court why it is you're not being allowed to see your children. And a lot of men are not aware that they can do that. It is written on the order. It says liberty to apply, but unless somebody explains to you what that means whenever you have a concern in relation to something in this order, or someone is breaching this order in whatever way, you can come back to the court, and the court will deal with the situation. And if it is that you're not being allowed access to your children, you can bring the matter back up before the courts.